Good morning. Today is September 25th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every week, we are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. I'm delighted to be working with Jean Lawler, David Schraga, and Michael Schwimmer to put together another exciting episode for you each week. And as you know, there's no charge for these great presentations. We ask you to contribute to a food bank if you like what you see. And one of the best parts, one of my favorite parts of the program each week is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers since we began the series in 2020. Jean Lawler, would you please do the honors?
Well, my pleasure. Good morning, everyone. Good afternoon, good evening, whatever in the world you are, whatever time it might be. It's great to have you here back again for another great presentation. Today, I am so excited to see how close we're getting to 900,000. We have been told about $877,506.28 in donations to food banks and similar locations around the world. So this global legal community is just incredible. As I like to say, feed your minds while feeding the world. So thanks so much. That's our number, Jeff.
Fantastic. Thank you so much, Jean, and thank you to all of our great speakers and all of those who have contributed in their honor. Now, today we have another great presentation for you from Jordana Feldman, Jordy Feldman. She'll be talking about how mass claims settlements can help restore a sense of agency and dignity in victims. By definition, settlements arising from mass tragedies address a large number of claims, often after years of contentious litigation. How can special masters and settlement administrators balance equity and efficiency when determining compensation and allocating damages among so many eligible claimants? The sheer volume of claims can make individualization a challenge, but an individualized approach, to varying extents, can be critically important in validating a claimant's experience and assuring a claimant's sense of justice. We will discuss what that looks like, the many considerations at play when designing and administering mass claims programs, and how the guiding principles in those programs apply in the traditional mediation context. Jordy Feldman is certainly an expert in this. She has spent most of her career serving as an independent neutral, designing and administering litigation alternative mass claims resolution programs and mediating highly sensitive emotional disputes. She has extensive experience in cases involving sexual abuse and sexual assault, personal injury, and wrongful death, having run programs to resolve claims of sexual abuse against Jeffrey Epstein and his estate, and against clergy and faith-based organizations, as well as serving for many years as Deputy Special Master of the September 11th Victim Compensation Fund. Jordy, we're very much looking forward to a fascinating presentation. Please tell us a little bit about the food bank to which you would like, or the organizations to which you would like people to contribute if they're able to do so. And then on with your presentation. The floor is yours.
Thank you, Jeff, for the introduction, and also to Jean and David and Natalie. What a wonderful organization. So I selected two organizations that my family has been involved with for years. One is Mandala Cafe, based in Harlem. It's a very special grassroots organization that provides hot meals to members of the community. Volunteers come together and prepare and cook and then serve the meals. Before COVID, we would actually sit down at the tables with those people that we were serving and engage in conversation. And what I love about this organization is that it's not just about the food. We know how conversations around the dinner table can be so important, and that dimension may be missing in their lives. And Mandala also provides culinary training and job placement services. So they're providing meals and also providing a sense of connection and dignity. The other organization I selected is Backpack Buddies, also based in New York, which provides children-facing food insecurity with backpacks filled with healthy food for weekend meals. What I love about this organization is first that it fills a void. It recognizes that these children who may receive free meals at school during the week may go hungry on the weekend. And second, that it's led by teenagers. It empowers teens to make a difference and model what empathy and service look like. I suppose it's no coincidence that these are organizations that speak to me, because their missions mirror some of the guiding principles that I find to be such critical components of the work I do. Empathy and empowerment, treating people with dignity, and I'll talk more about that in a moment. But just before I do, I just want to say how much I appreciate being invited to speak at this group. Jeff, you've managed to bring together people on a weekly basis with expertise in a particular area who want to share their perspectives and educate others, people who want to learn areas that they may not know about, and people who want to serve an underserved community. So as I see it, there's a common thread here, which is people who care. And what a great group to be a part of. So the topic today is, as Jeff said, mass claims settlement programs. My plan is to spend about 20 to 25 minutes sharing some of my experiences with these programs, how you balance equity and efficiency, and how you try to provide those affected with a sense of agency and dignity through the process. And then I'll leave for time for questions that will be moderated by Jeff. So my first introduction to this type of work was in the late 1990s. When I was a 2L in law school, I took a course on mass torts. My professor was just visiting for the semester, a man whose name may ring a bell, but was not a household name at the time, Ken Feinberg. He was then, as he is now, larger than life and a storyteller like no other. I'm sure many of you on this call know him or have seen him speak and know exactly what I'm talking about. The thrust of his class was, how do you deliver individual justice in the mass tort context? At the time, we talked about cases like Agent Orange, in a way like that was practical and personal, and that was infused with a sense of humanity. The topic and that approach just resonated with me then and continues to resonate with me over 25 years later. On the morning of September 11th, I was a young lawyer working at a corporate law firm in Lower Manhattan and was downtown heading into my office. As anyone who was down there will remember, there was such a sense of confusion at the time. After the towers fell, I took refuge in the Staten Island ferry terminal with a colleague until we decided to leave and walk home up the FDR Drive, which, for those of you who don't know New York, runs up the east side of Manhattan and was filled with thousands of people covered in dust and ash making their way home. I remember going back to the office a few weeks and even months later. You could still see and smell the burning embers. It was eerily quiet. You had to walk around barricades and rescue workers. And I remember having a moment of clarity, having this overwhelming feeling that I wanted to do something more meaningful. So I called my former Professor Feinberg, who'd been appointed as special master of a federal fund to compensate those affected by the attacks. And I asked if I could help. Fortunately, he said yes, and that put me on a career path that I never would have expected. I joined a small and extraordinarily committed group of people deputized to develop policies and meet with families of those who died and make decisions about who was eligible and how much compensation was appropriate. The overarching challenge that we dealt with the 9/11 fund, which is known as the VCF, or Victim Compensation Fund, both the original iteration that was established 11 days after the attacks and the reconstituted fund that was opened 10 years later to address the thousands of claims of people who got sick or died from their exposure to toxins in and around the World Trade Center site, was this. The statute mandated that we consider the individual circumstances of the claimant. That's because the program was intended to track, at least to some extent, traditional tort concepts in the civil justice system. It also mandated that we make determinations quickly. We had thousands of claims to process in an expedited time frame. How do you do that successfully? How do you balance these potentially competing directives? Well, to the extent allowed under the statute, we offered choices to vest claimants with a sense of agency and control over the process. They could choose whether to participate in the program or pursue litigation. They could elect what type of process they wanted. Did they want a review on the papers or an opportunity to be heard? And if they wanted a hearing, they could choose who came with them and what issues they wanted to focus on. That piece, the opportunity to tell the story of one's loved one before a neutral, proved to be such an integral part of the VCF's success. More often than not, we found that a claimant just wanted to talk about their spouse or their son or their mom. They wanted to see with their own two eyes that someone on the other side of the table was listening, that it wasn't just some government bureaucrat punching numbers into a calculator to determine how much their loved one's life was worth. And we found in the 9/11 fund and others funds that these programs are as much about validation as compensation, an acknowledgement of suffering, their loss, and the impact it's made on their lives. Now, it's not always practical for a claims program to offer a hearing or a meeting in every case, given the number of claimants or the time frame to process claims or the amount of funding or resources available. In the more recent iteration of the 9/11 fund, there are limits on what is appealable, what a claimant can request a hearing about. Over 100,000 claims have been filed in that program, and they just can't accommodate a hearing or appeal in every case. In terms of balancing individualization and administrative efficiency, when it came to valuation, we made presumptions that applied to all claims to ensure speed and consistency, but gave claimants the opportunity to present information that could support a departure from those presumptions. We took a hybrid approach. So, for example, we issued a standard non-economic loss or pain and suffering amount to those who lost a loved one on the grounds that it was impossible to differentiate between the amount of suffering among victims and family members, and it was administratively more efficient to implement. And when it came to economic loss, we used individualized inputs like age and earnings, coupled with presumptive values based on national statistics regarding things like work life expectancy. But claimants could make a case that those presumptions shouldn't apply for some reason. Maybe there was a special needs child or some other extraordinary circumstances that warranted consideration. We also leveraged third parties, employers, government, and other entities to obtain and verify information about conditions, causation, disability, and loss, and would often rely on determinations made by those entities. For example, the reauthorized 9/11 fund has a companion program, the World Trade Center Health Program, that provides medical monitoring and treatment to eligible individuals. The fund relies on determinations made by the health program about whether someone's 9/11 exposure caused or contributed to their condition when evaluating whether a claimant is eligible for compensation. And we established strong relationships with our counterparts at the health program and open lines of communication so that we could coordinate efforts and discuss how our respective policies might impact the other and any unusual cases that may not fit neatly within the framework. So let me take a step back for a minute and zoom out to address mass claims programs more generally, because I think it provides some helpful context. I feel like I'm back in my law school classes, but here goes the short version. So a fundamental principle of tort law is that people should be compensated when they're harmed by others. And it's traditionally focused on the individual, a single identified plaintiff. So what happens when you're dealing with a situation involving dozens or hundreds or thousands of people who may have been injured or exposed in different places at different times and in different ways? Well, significant challenges arise when you're dealing with mass claims in the litigation context: procedural, substantive, causation, due process issues. And the costs and delays and risks and uncertainties of litigation, which all of you seasoned mediators understand well, are amplified in the mass tort context. It takes an average of 7 to 10 years for mass torts to reach resolution. And when claims are aggregated, individualization is compromised. Mass claims programs can offer a meaningful alternative to litigation, and they operate as a sort of hybrid between mediation and arbitration. Participation is voluntary, like in mediation, but there's a neutral, a special master or an administrator who has the authority to impose a resolution like arbitration. They can be tailored to meet the needs and interests of the parties, and they can be fashioned in a way that engages and empowers the individual affected in a way that aggregate litigation cannot. It is an imperfect exercise. It's rough justice, as Ken Feinberg will bellow in his heavy Bostonian accent. I can see Jeff laughing because he knows. But the goal is to deliver some measure of individualized justice to the affected community in a fast and fair way. And that necessarily involves some compromise. I often think about guiding principles and how they inform the design and administration of claims programs. In the 9/11 context, we developed 3 guiding principles that speak to this difficult balancing act: faithful to the statute, fair to claimants, and defensible to taxpayers. Bert Newborn, a longtime professor at NYU who served as lead plaintiff's settlement counsel in the Swiss banks litigation, the class action lawsuits in the 1990s alleging that the Swiss banks colluded with the Nazis to conceal assets of Holocaust victims. He joined my class at NYU last year and shared what he saw as the guiding principles of that claims program, which he cited as exit, voice, and loyalty, a framework that's used in political science to explain how people can respond when they're dissatisfied with the status quo. I like to think of a slightly modified version of guiding principles in terms of how you deliver individualized justice in mass claims programs, which is choice, voice, and compassion, vesting individual claimants with the ability to choose among options to achieve some measure of justice, to express themselves and be seen and heard, and to be treated with the compassion and the dignity that they deserve. These principles are particularly important in cases involving sexual abuse. Sexual abuse at its core is about power and control. Abusers prey on the vulnerabilities of victims, and victims lose a sense of agency. Claims programs can be designed to empower victims by allowing them to make choices about whether to participate, whether they want an opportunity to be heard, whether they will accept or reject an offer, to tell their stories confidentially to a special master or an administrator. In litigation, courts may not allow a plaintiff to proceed anonymously. For example, a civil case against Sean Combs in the Southern District of New York was recently dismissed, where the plaintiff had filed under a pseudonym and refused to file the complaint with her name. That presents an extraordinarily difficult situation for victims of sexual abuse who don't want to have their stories broadcast publicly. Many claims programs are designed to be non-adversarial, unlike in the litigation context where sexual abuse victims are interrogated and routinely have their character called into question and are often re-traumatized in the process. In claims programs I've been involved with, we're not looking to discredit the claimant. We're looking to understand what happened, to evaluate that account in the context of available information, and understand what impact it had on them while treating them with sensitivity, humanity, and respect. I have found in these cases that there is a profound sense among victims that people in positions of authority turned a blind eye, that they failed to treat the victims with dignity and respect, and that they were deprived of opportunities to receive any sort of meaningful justice. That background significantly influences the design and the processes and the guiding principles of the claims programs that I've been involved with. And these concepts, choice and voice and confidentiality, are, as I'm sure you recognize, the same bedrock principles that apply in the mediation context. Mediation is a voluntary process. The parties have an opportunity to express themselves confidentially and be heard and make decisions about whether to accept a proposed resolution. A few closing thoughts to keep in mind. First, everyone experiences trauma and loss differently. People who may share objective characteristics to people who were the same age and suffered the same type of abuse at the same time for the same amount of time may experience that trauma in very different ways. People have different views of what justice looks like to them. And loss and money are two things that most people feel very uncomfortable talking about. When it comes to tragedy and loss, our human instinct is to look away. Even good, well-meaning people don't know what to say or how to help. And so the person suffering is often left to suffer in silence, which may exacerbate the feelings of isolation and hopelessness that are so commonly associated with trauma. In these cases, the discomfort is compounded because victims may feel conflicted about getting compensation, particularly from an actor or entity that they allege is the source of their harm. And of course, no amount of money can truly compensate for the harm they've suffered and the impact it's had on their lives. But one thing I've found is that creating an environment that allows a victim to make choices and provides a safe space for that person to share what is probably the worst thing that has happened to them, and to be seen and heard and validated, can bring a sense of healing and empowerment. I will leave it at that, and Jeff, I will hand it back to you for some questions.
Thank you, Jordy. What a fascinating look into the world, this world, and amazing at the role of individual attention and compassion and humanity in what is denominated a mass claims procedure. So in a conventional, let me ask you this, in a conventional mediation, there are times when we talk about apology and reconciliation and things of that nature. When you're dealing in these mass claims processes where there may be a manufacturer of a pharmaceutical that harmed somebody, or there may be representatives of a religious institution, perhaps not the individual perpetrators, but supervisory, executive people. Is there a desire, is there an opportunity for the claimants actually to meet with the executives of a pharmaceutical company or religious institution, or does that humanity and reconciliation, if you will, come from the dialogue with the claims administrators alone?
Yeah, it's a great question. So in the programs I've been involved with, it's unusual that there is any sort of direct interfacing at least that I'm aware of, between the victim, the claimant, and the institution or the alleged tortfeasor. I have had cases where there have been requests, and I will often act as go-between to see if that's something that, the defendant would be open to. But I think it's not typically something that's, included as part of a claims process. I think an interesting, just anecdotally, is that I don't get many requests for that. And I think part of that stems from, in concept, an apology or some admission of wrongdoing might seem like it would be very helpful. But we've all been in situations where someone apologizes and it really doesn't move the needle, right? I'm sorry you felt that way, And so how an apology is framed or how an acknowledgement is framed is so critical. And so, I wonder sometimes if maybe the lack of interest expressed to me through claims programs to have that conversation may be based in part of a resignation that an apology is probably not going to make much of a difference anyway. But I don't know.
Yes, I understand. An apology for consideration is not much of an apology, right? I'm sorry, now will you take less money? Or one that looks theatrical or rehearsed. So what implications does that have for sort of the standard mediation, not in a mass claims context, but just the kinds of plaintiff versus defendant lawsuits, which are more commonplace? What does that make you think about the role of apology and forgiveness and that sort of thing in more typical mediations?
Yeah, I mean, I think it depends in part on the context, as we always like to say as lawyers. But I think in a situation where there is some ongoing relationship, having, trying to restore the relationship to some extent is more important than in a situation where you want nothing to do with the other person ever again. And no apology is really gonna suffice. So, but I do think, people have different interests going into mediation or litigation. You want accountability, you want compensation, you want transparency. And so teasing out what it is that someone actually wants and whether it's something that is feasible is something that obviously happens all the time in the traditional mediation context.
So that teasing out of what people actually want, what do you find are the keys to doing that effectively?
It's conversations. I spend so much time early on in programs just engaging the stakeholders, understanding, at the beginning it's the lawyers, but ultimately, I will talk to, in many cases, the claimants, or in some, some case, it depends on the program. But I want to know as much as I possibly can from plaintiffs' lawyers who their clients are, what their concerns are, what their, what is really important to them. And, that allows me to both create and design a program that tries to address some of those things. And then when actually administering it, to apply those concepts, to be mindful of them during the process itself. So I think the conversations with plaintiffs' lawyers, I think for me, when I meet with the claimants themselves, it's typically not more than an hour or two. And I'm meeting them for the first time. I've read their file, but I really do rely also on plaintiffs' counsel to know, what are the trigger points? Where are, I am constantly monitoring body language and if there's a line of questioning that seems to make someone really uncomfortable, I don't need to know it. We're going somewhere else. And so, I generally will rely on the plaintiff's lawyers who know their clients better than I do, but I am constantly vigilant about someone's body language that suggests that this is not a productive line of questioning and we're going to move to something else.
So the whole question of establishing rapport quickly with people is something mediators, we spend a lot of time talking about that. You do it, you've done it so many times. Let me ask you, what are some traps for the unwary, things that a naive mediator or claims administrator might think, oh, this is a great way to approach people, but it just backfires. What should we stay away from?
I think one is just dictating what you will be doing or what the process will look like. So much of it, I think, is, as you know well, Jeff, it's inviting input, it's making, this is the party's process. So, I may be envisioning this to try to help structure the process, but what are your thoughts on that? I think just insisting on a certain way of doing something is, even just the way you go about the process can be problematic.
There's a question in the chat from Michael Schwimmer complimenting you on an excellent presentation and asking whether the approach is different if you're talking about financial loss, as in a Bernie Madoff type situation, for example, versus physical injury if you're dealing with pharmaceuticals and then there's, of course, the psychological injury, which I assume plays a bigger role in clergy type cases.
Yeah, I mean, financial loss is quantifiable, right? More easily quantifiable and less subjective. There is some measure of subjectivity in determining loss for non-economic loss, pain and suffering. And so there is a very delicate balancing act where you want to consider the individual circumstances of each claimant, but you also want to make sure that you're treating similarly situated claimants similarly. And so, when you do have it, like in the 9/11 context, as I mentioned earlier, we issued the same amount of pain and suffering loss for anyone who died. And there were requests through the regulations, after notice and comment about, well, my loved one was trapped in the building for this period of time and we were on the phone and so there, that should weigh into it. And we just felt like we don't know how to distinguish between those types of cases. In the more recent iteration of the 9/11 fund, because there are so many claims, it has become a little bit more structured in terms of, what condition you might have and what type of pain and suffering amount you might receive. So again, there's this, the approach is there's a default amount. If you are diagnosed with asthma that's determined to be related or caused by your 9/11 exposure, you may get a default amount. But if you have proof that it's actually severe, you have medical records, you have a doctor's note, then that would support a departure from that default amount and would get something higher.
And Jordy, there's all kinds of studies, for example, criminal defendants who get sentenced before lunch versus after lunch or the beginning of the day. I'm sure you've seen those kinds of studies where people who are making decisions think they're being internally consistent and treating similarly situated people similarly, and yet researchers have published various studies saying, well, that's not true. So how do you protect yourself against making uh, inconsistent decisions when we know from these studies that whether you're hungry or not, or whether it's the beginning of the day or the beginning of the week or the end of the week, can have perhaps significant impact on the decisions that you're making?
Well, one way is just internal audits. You know, you take representative samples of claims over periods of time and make sure that you are applying the policies consistently. You know, another way is having another set of eyes in the room or in the decision-making process. You know, I often like to have a second person sitting in meetings or hearings with me who may hear something that I didn't hear, that may be material to the decision. Or, you know, oftentimes, like there was a period of time at the 9/11 fund where we were trying to address a backlog, and we're doing, you know, 7 hearings a day. And so the fatigue that sets in at the end of the day, to your point, you know, you're missing things that are important. And so we would always have at least 2, a hearing officer and someone else in the special master's office sitting in on those hearings. So as a kind of gut check and fill in the gaps and making sure that we're addressing things as they should be addressed.
And then, Jordy, you've talked about the relationship between the establishment of these funds and programs and the administration of them. So how does it work, and how involved are you as the claims administrator, special master, in the establishment of the program and then in its administration? And then as the administration of the program goes on, if you see things that aren't working quite as well as you'd hope they would, how then do you go back to the legislature or whoever established the fund and make some mid-course corrections if you have to?
Yeah. I mean, I would always say if in the ideal world, the people who are administering a settlement are involved to some extent in the design process, because invariably the people who are negotiating the settlement don't understand some of the operational difficulties that a certain policy might present. You know, on paper it looks great, but it's difficult to implement, or it creates all of these downstream unintended consequences. So in an ideal world, the special master, the administrator would be involved in the discussions about what that process and what the criteria would look like. Obviously, in a situation like the 9/11 fund, it's statutory. So we had some say in terms of, you know, putting out for notice and comment the regulations, getting input, and then figuring out how to address certain issues. And, you know, that can be complicated in terms of providing enough transparency, but also building in some cushion room so that if as you say, something comes up down the road, you're not hamstrung. You haven't issued regulations that prohibit you from doing something, even though you realize down the road that actually would have been the right thing to do. Now, you know, as when we were at the 9/11 fund, which is administered by the Justice Department, we can't go to Congress and say you need to change this. But a lot of the decision making was in and why the statute ended up being reauthorized and then permanently authorized was that we were communicating regularly with the public and with, you know, legislative aides and whatnot to say, look, we're running into challenges here. I mean, in 2019, we we were supposed to, in the 9/11 fund, it was supposed to wind down. And we were running out of money. And, we had a limited appropriation. We had far more claims than we ever anticipated. We had been, doing projections based on historic trends, based on what historically had happened, based on trends we were seeing, based on what we had known from what was happening through the health program, and realized like we didn't have enough money to pay all current and pending and projected claims. And so we decided in that instance to be transparent about it, to go out. We put out a notice of inquiry through the Federal Register, and asked for input. Like, how should we address this? We had a series of meetings with plaintiffs' lawyers and other stakeholders. What's your suggestion? How would you recommend we address this? And I think it was by virtue of that transparency that it got, galvanized a group of advocates to go back to Congress and say, this is not right. We need to fully fund this program. And that turned into not only fully funding it, but also extending it for decades in the future.
So can you explain how that works in a little more detail? You say you put it out for comment in the Federal Register, you went to Congress. To those of us who don't work in this universe every day, that sounds kind of highfalutin, How does it really work?
Yeah, well, it's funny. I mean, I wrote some of the regulations in 2016 when we were first reauthorized. And it is funny how you can be known as a resident expert when you know just a little bit more than everybody else. And it's I think, as with most things, it's not highfalutin. It's really more of a grind, and about relationships, and about having conversations to say, we had really developed great relationships with the doctors and the administrators at the health program. And so we were able to exchange information between us and kind of present, a coordinated effort. We had developed great relationships with the plaintiffs' lawyers, who, after years of having gone through this process, felt like they could trust us, that we weren't going to do wrong by their clients. I mean, you always have to tease out, well, what is if someone proposed, well, why don't you just keep paying, just keep paying what you have, and then the money will run out. Well, that is one way we could have done it. But then, I mean, what happens to those people who are left out in the cold? What if the funding never comes? And so, it's relationship building and cultivating and revisiting over and over and over and over again. And so, by virtue of the conversations with plaintiffs' lawyers, and then with people, in Congress who had drafted the original legislation and had different expectations in mind in terms of what it was going to look like over time. It was really them. They were the ones who kind of took it and ran, and then really embarked on these advocacy efforts to push Congress to provide more funding and provide more time.
It sounds like quite a mediative function, where the claims administrator is not really a disinterested observer, but rather highly motivated by the commitments to the claimants, to the taxpayers, and to the will of Congress or whatever legislature is involved. Fascinating. We have some questions from folks in the audience. Dimitris Mvalomenos If you'd like to unmute yourself and pose your question, you were first in the queue. Perhaps not here
Yes,
any longer. Oh, there you
sorry.
go. Yeah,
Yes,
please, we can
sorry.
hear you. We can hear you. Please go ahead.
Well, first of all, many thanks and congratulations for the presentation. My question is it mandatory or voluntary, the mediation process in those mass claims? I suppose it depends on the state. And secondly, my question is how the representative negotiates the compensation amount? Is it a kind of pool? Is there any pre-mediation arrangement about the participants, the victims? How are the amounts negotiated and calculated? Thank you.
Yeah. So to the first question, they are voluntary. I've never been a part of a program that's been mandatory. But they can be structured differently. Like in most cases, they're voluntary, and you don't waive any sort of litigation rights unless and until you accept an offer and sign a release. The 9/11 fund was a little bit unique in that you waived your litigation rights upon submitting a claim at the very beginning, and that was by statute. So you're more limited in terms of choices, and if you don't know what you're going to get, and you're waiving your rights at the outset, that's a scary enterprise. So in the 9/11 context, for example, we would do these elaborate illustrative examples of a claimant, a victim who was 35 years old, firefighter with 2 kids earning something, and we would post them on the website. This is what an award might look like. And so, in terms of negotiating the compensation amount, there are some programs that have a fixed pool of assets. So you need to know, in terms of divvying that up, it can be complicated because you often don't know the total universe of claimants, let alone the universe of claimants who are eligible to receive money, right? You might have 100 people who apply, but only, 80 people who are eligible for compensation. And so until you've evaluated all of those claims, you don't know how much they might get. I mean, maybe you issue some sort of, pro rata amount at the beginning and then, offer some more once you know the total population. But, there are other programs like, 9/11 at certain points. The NFL concussion settlement has no cap, but they have kind of pre-designated amounts, like a matrix value, basically. So if you have, this condition, you played for this many years in the NFL, and you were between these ages, this is what you're going to get. So sometimes it'll be somewhat formulaic and transparent to claimants, so they have they know what to expect to a certain extent.
Thank you.
Thank you. David Schraga, you have a question in the queue. If you'd like to unmute yourself, please.
Thanks, Jeff, and thanks, Jordy. Just to follow up on that point, Jordy, to what degree do you find yourself in a position where you have discretion to make a decision about what the ultimate outcome should be or award should be for someone? Because it sounds like you're imposing a resolution often, and what it makes me think about in the context of a mediation is it's almost like an inversion that happens where you're effectively like the person from the insurance company, the person with the power of the purse who has to make this decision about what's an appropriate resolution, what they're willing to pay. Do you ever find yourself in that situation where you feel that tension, and how do you think about that?
Yeah, most of the programs I am involved with have, it's a mix of some objective criteria and subjectivity. And I do have discretion. It's based on, judgment based on the information available, prior experience and expertise. I think about it all the time. I think about what a decision would mean in one claim for other claims. And so, it does feel, I think one of the ways that I think about it is if I do something, if I exercise discretion that someone doesn't agree in a way that someone doesn't agree with, the process is voluntary. They don't have to accept the offer. It's not binding until the end. And so, I often, I take the responsibility very seriously. I allow for reconsideration. I try to build that into the process. If there's something I just got wrong or there's information that wasn't available that is material to my decision, and there's an off ramp for someone who doesn't agree with it at the end of the day, who says, you know what, I now I can make a more informed decision about whether this is an offer I want to take, and yes, I do, or no, I don't, and I'll pursue whatever other options are available.
That's helpful. And just to follow up on that as well. So you also talked about the importance of providing a safe space for people to be able to tell their story and to have that sort of emotional outlet as part of the process. And as mediators, we often talk about the importance of doing that in mediation and the tension that exists between being a lawyer mediator versus a mental health professional or a therapist. And I wonder what resources are available within the context of these settlements to help navigate that. And how do you sort of, maybe on a personal level, take care of yourself in terms of living through these heartbreaking claims and dealing with this, what I imagine is for years and very difficult, painful stories?
Yeah, that's such a good question. On the issue of resources, when I first started doing sexual abuse cases, I just wanted to educate myself as much as I possibly could about the dynamics of sexual abuse and common outcomes. And so I spent a lot of time reading and talking to experts in the field. We ended up having, in one of the programs, we ended up having a nationally renowned sexual abuse expert who served as a consultant for the program, and did a series of trauma-informed training for me and my small staff. And so, I think that is all incredibly important. And I also think, as anyone who mediates recognizes too, it's so much about just listening and being a human being, showing some humanity through the process. I have an exercise that I do with my students, that when I don't say what it's about at the beginning, and I get a lot of eye rolls at the beginning, but they all understand at the end. And that is, I pair them up and have them tell the other something challenging in their life, and then they switch, and then they tell the other person, and then we regroup and talk about how it felt to tell the story and how the other person responded in ways that were helpful or maybe made them shut down. And the point of the exercise is really just to try to put you in someone's shoes who's telling a story like this. And as I often remind my students, like, you chose what story you got to tell. And I'm sure they kind of they oftentimes will take something that's really not that deep because they don't want to get into it. And recognizing the people who are coming to these compensation programs for some measure of justice, they're really talking about this horrible thing that has impacted their life in so many profound ways. And so, I think just constantly thinking about, how the other person may be responding, reading cues, understanding how the way someone responds can either open someone up or shut someone down. I mean, you all know this as mediators. I think that is so important, just that kind of self-education. And in terms of my own self-care, I mean, I've always felt like it's so important. It's so important for people to have opportunities to, achieve some measure of justice in a civilized, compassionate way. And so I really do think about it as I am in such a position of trust, and it's such a privilege. And also, it is hard for me, just as a human being, to hear stories. It's impossible not to feel for people who have gone through such horrible, traumatic experiences, and and trying to balance that, remaining objective. You do a disservice to someone without showing some level of compassion, but you can't allow that to drive the bus. And so in terms of my own self-care, I mean, I am, I realize that this is my job and I love it. And I also need to be doing things that keep me centered and grounded, like my family, like a good long run. Anything that kind of can turn my mind off for a little bit and reset is really helpful.
Well, thank you. And it's a tremendous act of service to people in the community. So thank you for what you do.
Thank you.
Yes. Tina Jones has a question here regarding COVID-19. People who, Tina notes that she's a survivor with long-term physical and mental damage. There are many of us who do not understand how we were able to move on, and there's no dedicated space to mourn the loss of so many innocent lives. Can this framework be applied to a COVID-19 fund? Any thoughts?
I'm a little rusty on this now, but I think there were proposals at the state and federal level to try to provide compensation. But, as with any claims program, defining the scope, of who would be eligible, and then if there are services that might be available, that's a whole other line of questioning. So, but yeah, I mean, there were, I know, efforts. I don't know how they ended up being resolved. But it's obviously an incredibly challenging time. It goes to the broader question about why does the federal government compensate for some things and not others? Why 9/11 and not the Oklahoma City bombing? There were questions about why the World Trade Center in 2001 and not in 1993, the bombing that happened there. So there are philosophical questions that are also, hard to wrap your hands around when there is so much suffering, not all of which is compensated for.
Thank you. David Tenner, we have just a minute or so left, so please unmute yourself and quickly ask a question.
Sure, I'll be very fast. I moderated a panel for the Academy of Court-Appointed Neutrals, and for those of you who do this work, please consider joining the Academy of Court-Appointed Neutrals about self-care for people who do this work. Ken Feinberg was on the panel, Debbie Greenspan was on the panel, Randy Roth was on the panel, there's the Boy Scouts. The gist was, one, if you do this work, do things that bring you joy to balance the work that you're doing. And the other was therapy. Therapy was endorsed by a large group of people who do this kind of work. It's mentally very draining. And hopefully that was quick enough.
Indeed it was, and it's a wonderful note on which to end. Thank you so much. Jordy Feldman, this was a fascinating, terrific presentation on the humanity that goes into the administration of mass claims where one might think there's not that much room for humanity, and you beautifully proved it otherwise. We hope that people who are in a position to contribute to Backpack Buddies or Mandala Cafe. We have the links in the chat, or any other food bank that's important to them. If people who do contribute would please inform us of their contribution, we'd be delighted to add it to our running total. On behalf of everybody here, our growing team at the Will Work for Food Project, Jordy Feldman, thank you so much for a terrific presentation. And with that, we are complete.